Good afternoon and welcome to the Environmental Law Institute. You've joined us for Hazardous Waste Insights. My name is Hannah Keating and I'm the Manager of Education Programs here at ELI. We're delighted to welcome everyone to the sixth seminar of our ELI's annual summer school series, and I encourage you to join us here every Tuesday for summer school. For more information, please see our events page on our website, eli.org, and thank you for joining us. At the end of today's panel, we'll have time for a question and answer session, and we encourage you to ask your questions at that time. If you're joining us in the room, we have a microphone to bring around, and if you're joining us through GoToWebinar, please submit your questions through GoTo's question box, and please do not wait until the end. Send them as soon as you think of them. I would also like to thank our outstanding panelists for joining us today to lend their leadership to summer school. While I introduce them briefly momentarily, their full speaker bios are posted on our website, eli.org, and I would encourage you to check out their expertise and experience in more detail there. As we begin, I would like to briefly introduce our panelists. Erin Agee is the Senior Associate Regional Counsel at EPA Region 8 with the CERCLA Enforcement Section. Her practice primarily focuses on CERCLA, but also RCRA, the Clean Water Act, and the Federal Insecticide, Fungicide, and Roticide Act. Susan Akers is the Assistant Section Chief in the Environment Enforcement Section of the Department of Justice. This section and her work handles civil judicial enforcement of the major environmental statutes, including the Clean Air Act, Clean Water Act, and CERCLA. Dr. Ravi Arulanantham is the Senior Principal Consultant at Geosyntec and has more than 20 years of experience focused on risk assessment and remediation management. His practice areas include contaminated site assessment and cleanup, environmental management, and water and natural resources. And lastly, but not, or final but not last. Lastly, what's the phrase?
Last but not least.
Last but not least, thank you. Allison Rumsley is a partner at Arnold, Porter, Kay and Schooler, LLP, and her practice focuses primarily on environmental litigation, enforcement matters, and regulatory counseling. Her expertise is in CERCLA, RCRA, and the National Environment Protection Act, and more. As you can see, we have a really fantastic panel with a wonderful variety of experience and expertise. Thank you all so much for contributing to the 2019 Summer School Series. And with that, I'll turn things over to you, Susan.
Thank you. So as Hannah said, I do civil environmental enforcement, judicial enforcement, and so I'll be giving an overview of CERCLA, and it will be with sort of my bias in mind, given that I do enforcement, so I won't be talking as much about selection of response actions and things like that. So I'm just going to talk briefly about the history of CERCLA, the liability scheme, defenses, and then I'll talk about a few other issues that are interesting to me. So CERCLA is the Comprehensive Environmental Response Compensation and Liability Act, and it was passed in 1980 in response to several environmental disasters, and there was no mechanism to clean these up. So the first one was Love Canal, where there were buried drums of hazardous waste that were starting to come up behind people's houses. And Times Beach, Missouri was another example where there was dioxin that was in oil that was used for dust suppression on roads in a vacation area. And so once people realized they were getting sick from these, there was no mechanism to clean them up. So Superfund is the term used colloquially to talk about the fund that is used to clean up. So when CERCLA was passed, it created the Superfund to be used for this purpose. There are two primary ways to get a cleanup action done. The first we call fund lead, and that is where EPA taps into the Superfund and does the work themselves, and then we can go later and recover that money from responsible parties. Or if there is an imminent and substantial endangerment, and under the law that is not necessarily as imminent as you might expect given the words, then an EPA can issue an order for private parties to do the work under Section 106 of CERCLA. So when the statute was first passed, the Superfund was funded at $1.6 billion, and there was a tax on certain chemicals and petroleum products that would replenish the fund. that tax expired in December of 1995. So now there are annual appropriations to the Superfund, and then the only other way the Superfund is replenished is through cost recovery actions, and brought by EPA administratively or Department of Justice. Okay, so who is liable under CERCLA, and what can we recover? So under Section 107 of CERCLA, it sets forth the liability scheme, and the federal government, individual states, and tribes can recover what we call response costs, costs incurred in response to the release or threatened release of hazardous substances. And the standard for recovery is all costs incurred not inconsistent with the National Contingency Plan. So what is the National Contingency Plan? The National Contingency Plan is set forth at 40 CFR Part 300, and it sets forth a framework for the selection of response actions, for the procedures for investigating and selecting response actions. It does not sort of state what costs, it's not directly related to costs, it's related to response actions. So when the statute says that EPA can recover all costs not inconsistent with the plan, it really means that their actions, the only way to prevent recovery of response costs is if the actions, underlying actions, were actually inconsistent rather than looking at individual costs. The way it's worded, not inconsistent with the National Contingency Plan, creates a presumption in favor of the plaintiff that the costs were incurred consistent with the plan. So the burden shifts to the party against whom the cost recovery action is being pursued to prove that those costs were inconsistent. And I will pause a minute here to say there's two types of cleanup actions. There are removal actions, which are the shorter term, maybe time sensitive actions to clean up. And then there's remedial actions, which are intended to be the permanent long-term cleanup action for a site. And those two different types of actions are addressed in the National Contingency Plan. They have different statutes of limitations as well. Now, private parties can also recover under the statute, but they don't get the presumption that the government plaintiffs get. So the standard for private parties is they can recover any other necessary costs of response consistent with the National Contingency Plan. So the significance of the difference in wording there is that they have to prove that the costs were both necessary and consistent with the National Contingency Plan. So the categories of liable parties are set forth in Section 107A of CERCLA, and they include current owners and operators of facilities where there's been a release or threatened release of hazardous substances, owners or operators at the time of disposal of hazardous substances. So if a party owned the property, no longer owns it now, but it can be shown that while they owned it or operated it, that's when the disposal occurred, then they would be liable. Next one is, colloquially, we'll call it generators of hazardous substances, or people who arrange for the disposal or treatment of hazardous substances. So this, the classic one would be a manufacturing facility that has hazardous substances as a waste product, and they send them off to a landfill or something, and then that becomes a Superfund site later. They will be liable for that disposal. And finally, transporters of hazardous substances, when those transporters have selected the site where the hazardous substances will be disposed, are also liable. So the liability scheme under CERCLA is strict liability. There's no negligence standard. No, you don't have to have any knowledge of how it was disposed of. The liability is joint and several, which means if there are two parties who are responsible for the harm, for the disposal and the harm to the environment, either of those parties can be held liable for the entire amount of the cleanup. And liability is also retroactive, so we can pursue parties for disposals that occurred before the statute was passed in the 1980s. And in fact, it was intended to clean up historical contamination. So because it's strict liability and it's joint and several liability, where one party can be held liable for all of the costs, the statute provides under section 113F for contribution actions. So one liable party can seek contribution from another liable party, and there courts will consider equitable factors in determining what amount each party should pay. So what defenses are there to liability? There are 3 enumerated defenses in section 107B of CERCLA, and they are not particularly successful. The first is an act of God, which you know, sounds like a hurricane or something like that might be considered an act of God, but the party has to have, it has to be an act where the party could not have foreseen it and could not have prevented the result. So given the fact that we know there are hurricanes, we know there are severe weather events, that's not likely going to get you out of liability under the statute. An act of war, similarly, theoretically, if your facility is bombed by you know, another country, then perhaps that could get you out of liability. But things such as the case here, Shell Oil, you know, if it's related to conditions of a wartime contract or things like that, that's not going to get you out of liability either. The courts have interpreted the term act of war consistent with other statutes as well. So you can look to other case law for interpretation of that. And the final defense is the act or omission of a third party. So if a third party caused the disposal and the release of hazardous substances under this section, and it's 107B3 of CERCLA, you could argue that that person is liable and you are not. However, it has to be someone with which you have no contractual relationship. So that actually cuts out a lot of potential defenses here, because if you are in a landlord-tenant relationship, for example, and you are the landlord and the tenant caused all of the contamination, that is not going to get you out of liability here, because if you have a contractual relationship through the lease. So the classic case here would be that of midnight dumping. If someone just passing by your property that you have no relationship or knowledge of dumps hazardous substances on your property. But you also have to exercise due care and take precautions against any foreseeable acts or omissions of other parties. So just a few other issues under the statute, and some that I've been personally involved in and find interesting. Also under the statute, the governments, both the federal government, states, and tribes can recover for natural resource damages. So natural resources, I have the definition here. So it can be, you know, wildlife, biota, air, water, groundwater, drinking water, all of those things that have been harmed by contamination with hazardous substances, we can recover for. Any recovery for natural resource damages has to go directly towards restoration of the natural resources that were damaged. And these actions can be brought by, there are trustees of natural resources. So the states are trustees of certain natural resources, tribes are trustees of resources that relate to their reservation lands. And the federal government has trustees. The trustee agencies for the federal government are the Department of Interior through the Fish and Wildlife Service. NOAA is a trustee for any natural resources relating to oceans. Then any agency that owns land, so the National Park Service, the Forest Service, they would be trustees for lands, their natural resources on lands that they own. So the response action selected by the agency can be challenged as arbitrary and capricious, or inconsistent with the National Contingency Plan. But the statute bars an action to challenge those response actions except under certain circumstances. So we call this the pre-enforcement bar on review of the response action. So one can only challenge a response action selected once a cost recovery action has been taken against them, or they've been issued in order to perform work under Section 106 of CERCLA. Section 106(b)(2) of CERCLA provides a mechanism for parties who have been issued a 106 order and have performed the work to seek reimbursement of those costs if they were not liable. And so one could challenge the response actions in that such an action there also. I should mention here as well that a 106 order, if that is issued to a private party to do cleanup work, they must comply first with the order, and then they may seek reimbursement. They are not permitted to simply not comply. An arrangement for disposal of hazardous substances is one of the categories of liability. Some parties have tried to avoid liability by saying that the arrangement for disposal was not really a disposal, but the sale of a useful product. The Burlington Northern and Santa Fe Railway case is a Supreme Court case that addressed the sale of a useful product. And there the court said, it sort of introduced an intent element into liability under this subsection of the statute, where they said that a party must have had the intention that at least a portion of the product be disposed of during the transfer. So that was sort of a new thing where we have to look now towards the intent of the party. Did they intend to dispose of something, or was it a pure sale? U.S. versus General Electric is a case that was post Burlington Northern, where the court found it was not the sale of a useful product. This is an interesting case where GE was selling drums of scrap Pyranol, which is a hazardous substance, and they were selling them to a guy who just had a small facility and was using it in the formulation of paint. GE needed to get rid of this stuff. And there were sort of over time, the quality of the material degraded. They were throwing in rags and things like that into it. And Mr. Fletcher, who they were selling it to, began to stop paying because he didn't like the quality of it. Drums began accumulating. When the United States sued GE for the cost of cleaning up, GE claimed that this was the sale of a useful product. The district court found, and the First Circuit affirmed, that GE actually, even though they were charging money for this and Mr. Fletcher did have a use for some of it, that this was not the sale of a useful product, that because GE wanted to get rid of it, because GE didn't enforce the debt, they forgave the debt of Mr. Fletcher, the court determined that this was, in GE's mind, a disposal. Another more recent case, I've also been involved in this one, is U.S. versus Geico and Titan Tire Corporation. Here, there are these buildings called Butler buildings that are made of steel beams, and they can be disassembled and reassembled somewhere else, and they have value. So there were Butler buildings on the facility, DICO's facility here, but there were PCBs in the insulation and the material of the building. So they were under an EPA order to maintain the integrity, sort of a casing on the insulation to prevent the disposal or the distribution of the PCBs in the insulation. When EPA was visiting the site for a 5-year review, they came upon another company, a purchaser of this Butler building that was disassembling the building. The beams were taken to another site and a second Superfund site was created, and PCBs that were in the insulation were disposed of and released at the second facility. So DICO argued that this was the sale of a useful product, that these Butler buildings have value and that they were selling it. But the court found, and the 8th Circuit affirmed, and this case has a long history. It's been up to the 8th Circuit 2 times at least. But they found that because DICO kept it, did not tell the purchaser that there were hazardous substances there. They did not tell the purchaser that they were under an EPA order on how to maintain the building, and they did not really try to market the building to anyone else, that this really was a disposal and not the sale of a useful product. This case right now, as you can see, is a relatively recent 8th Circuit decision. There is a request for rehearing en banc pending right now. This one, so this is one to watch. So we talked about the fact that liability is joint and several. One way to get around that is if you can prove that it's not a single harm, that the harm is divisible. So an example of this might be a groundwater plume of hazardous substances, and maybe there's multiple sources and the groundwater is moving in one direction. If you were sort of a downstream party who contributed to a plume, you could argue that I'm not liable for, the part of the plume that needs cleaned up here because the groundwater is moving. I'm a down gradient from that. There's many other possible scenarios where you could argue that there is more than one harm, or that the single harm is capable of apportionment. The Supreme Court case Burlington Northern also spoke to divisibility and apportionment as well, and what the standard should be for that. The defendants, it's worth noting that the defendants bear the burden of proving that either there are distinct harms or that it's reasonably capable of apportionment. In a contribution action under 113, I mentioned earlier that equitable considerations are considered in determining how the liability should be shared among responsible parties. And in a divisibility or an apportionment case, equitable considerations don't apply. It's a matter of whether there are distinct harms or whether there is evidence to show that it's capable of apportionment. And finally, this is another case that I thought was interesting, that's relatively recent. The 9th Circuit in this case, Bakutas versus Tecominco. Tecominco is a Canadian company. It's a lead smelter, and the air emissions from the facility are traveling across the border into the United States and causing lead contamination in the US. There are multiple sources of contamination, both through water and through air. This decision addressed the contamination coming into the US through the air, and the 9th Circuit found that air depositions are not a disposal. So this is the first court, at least that I'm aware of, that has found this, and so is something also to watch here. It doesn't affect a lot of our cases. We don't have a lot of cases where we're looking at contamination from air deposition from stacks emitting pollutants. So, and that is it for me. So, Erin?
I'm here.
On to you.
Thank you. Can everyone hear me?
Yes,
Okay. And can everyone see me?
No.
we see your slides.
Ah, okay. I just tried to turn on my webcam.
Oh, wait, there you are. Excellent.
Hi. I'm sorry I can't, it's a little odd, I have to admit, being here in Denver and looking at my face on a screen and not being able to see who I'm speaking to. So I'm sorry I can't meet you all in person, but I guess virtually is the way that it'll have to be today. And let's see if I have control over the slide. Yes, okay. So Susan talked about some of the general liability schemes surrounding CERCLA, and I'm going to focus in on one of the aspects, which is specifically ownership, that category of liability. And I'll just make the classic disclaimer that any opinions that I express are mine and not those of the EPA. I thought that maybe if I somehow referenced Aristotle in my title, we'd have a good chance of having an engaging intellectual conversation. So that's the reference here. One swallow does not a summer make. Bare legal title does a CERCLA owner make, and we'll talk about a 10th Circuit opinion that came out in 2017 that discussed that piece. So as I was talking about, one of the ways that you can be found liable under CERCLA is as a current owner or a past owner at the time of disposal of hazardous substances. Though conveniently, for lawyers perhaps, depending on how you look at it, CERCLA does not define ownership, own, or owner. I think the closest we get is in 10120A. It says an owner is any person owning such facilities. So courts over the years have mentioned how this is kind of a not very useful definition of owner for us trying to figure out what all that encompasses. And then often, as is the case when a statute doesn't define something, the courts look to, what sort of reasonable interpretations can they make to figure out what ownership actually means for purposes of liability. So I'm going to spend most of the time talking about a 10th Circuit case. I'm in Denver. I'm in EPA Region 8, and we have the states kind of in the Intermountain West. And one of the things that we face is for most of our Superfund sites are what we call legacy mine sites, where the operators were there, in the 19th century and the 20th century and doing what they did. And then we're now figuring out how to clean those sites up. And by virtue of being out west, there's also a lot of land that's administered by federal agencies such as BLM and the United States Forest Service. And so this ownership question is in context of those federal land management agencies. So that's something that I have been dealing with in my practice over the past couple of years in light of this 2017 10th Circuit case. So I'm going to spend some time talking about that. And in order to contextualize the 10th Circuit's legal analysis around ownership and the Forest Service, we just need to have a tiny little bit of background on something called unpatented mining claims and then patented mining claims. So I'm going to spend the next couple of slides just giving the very, very basics around this so that we can have the context moving forward. So under the General Mining Act of 1872, citizens could explore the public lands, and if they found valuable minerals that they wanted to mine, they could then obtain title to the land where those deposits were. The title was considered title to what they referenced as an unpatented claim. And with an unpatented claim, the United States maintained the paramount title to that land, but the unpatented claim holder could still explore and have the right to mine. If the unpatented claim holder wanted more control over that claim, they could go through the patent process. And this is just a slide that describes, again, the very basics of some of the different property rights. So 30 USC section 29 outlines the steps to take to actually obtain a patent over that claim. There are certain maps you'd have to submit and affidavits as to certain locations and what had been done and not been done on that claim. But basically, if you have an unpatented claim, the claim holder, you have rights against third parties, but you don't have rights against the United States. So the United States maintains that paramount property title. However, if you go through the process outlined in Section 29, then you can have rights against third party and you have rights against the United States. And that was one of the benefits that entities found, is that they would have just more sticks in that bundle of sticks that we talk about for property rights. So with that, I'm going to dive into the case itself. It's Chevron Mining Incorporated versus the United States, and that's the citation on the top there if anyone's interested in reading the full opinion. It definitely has some interesting discussion on ownership pieces for CERCLA. Some of the facts, Chevron and its predecessors were mining molybdenum. This was in New Mexico, Cuesta, New Mexico. The full span was 1919 to 2014, with varying degrees of operations and ownership being transferred at different amounts. But that was the full span that they were involved. And then this resulted in hazardous substances being released. And according to the opinion, we talked about needing a cleanup that was going to cost close to $1 billion or over that. And then, of course, as we know with Superfund, it takes many decades to often clean up these more complex sites. So relevant for our discussion of ownership, the United States held fee title to portions of that Cuesta mining site, those lands, and they held fee title by virtue of the fact that Chevron had unpatented mining claims. But if you remember the slide before, just because Chevron held an unpatented mining claim, the United States still has paramount title to those lands. And they held it during the time that hazardous substances were disposed. And then the last thing that I wanted to do to cue the case up was that, as Susan mentioned, it's joint and several liability, but contribution is also possible. So when Chevron was looked to clean up the site, they then turned around and said, well, hold on a second, the United States is an owner here too. They then sued the United States under the contribution provision in CERCLA. They sought a declaration that the United States was also liable as a past owner. And the United States argued, as it had done before, that bare legal title wasn't enough to trigger that ownership liability. So again, as I was speaking about in the beginning, CERCLA doesn't define owner. Therefore, the 10th Circuit looked to what they called contextual clues to find the meaning. They looked at different provisions of CERCLA and found some indications for a couple of conclusions. 105A6 references federally owned or controlled properties, and because of that, they concluded that ownership is not the same as control. 105H4A references an owner or an operator or a significant contributor, and so they decided, well, that means that you can own without having significantly contributed. And then finally, they decided that, when you look at the definition in dictionaries and elsewhere, the ordinary or natural meaning of owner includes, at the very least, a legal title holder. So the United States argument in the Chevron case was not new. They were really relying on some precedent that had occurred before, and that's in the case called the United States versus Friedland. It was a 2001 case in the District of Colorado. It involved the Summitville Superfund site. And basically the argument for the United States was that, due to the history of the United States and the mining that was happening and the General Mining Act, that there was really a unique nature of unpatented mining claims on federal lands, and therefore it really demanded an exception to CERCLA's ownership liability provision. If you read Friedland, the main focus is on control, And the Forest Service argued that it didn't have sufficient control of unpatented mining claims in order for it to be considered an owner under CERCLA. It speaks about, not having notice of the initiation of possession of an unpatented claim, talks about how it doesn't have the ability to exclude persons from entering the lands that are open to mining claims. And also it talks about how the Forest Service has no contractual relationship with the possessor of the property. So those were its three main points based on, again, the kind of control theme. And it was based on this 2001 District of Colorado case. So to go in a little bit more into the District of Colorado case, Friedland, and see where the United States was coming from, the Friedland court had decided that bare legal title was not enough, and so therefore it adopted an indicia of ownership test. When you really drill down into what this indicia of ownership test is, it's, I think, quite vague, as some legal tests are. The court looks at the relationship between the United States as owner of their legal title and those entities utilizing the property subject to the unpatented mining claim. So it looks at the relationship between the United States and the unpatented mining claim holder, and then it decides whether that relationship is basically sufficient to merit the appellation owner for purposes of CERCLA. So not a whole lot of indication of what would be sufficient and what wouldn't be sufficient. But that was the indicia of ownership test that the Friedland court laid out and that the United States pointed to in the Chevron case. But the 10th Circuit rejects the Friedland test, and it does so looking at the statute. It says, if Congress had wanted to use indicia of ownership as a standard for all owners, it could have. There are a couple of different points in CERCLA where indicia of ownership is mentioned, and it's a way to demonstrate that you, in fact, are not subject to liability as an owner. 10120A, 10120E talks about a person holding indicia of ownership, lender holding indicia of ownership. And so the court said, again, if Congress had wanted to do that, they knew exactly how to do it because they did it in these other specific places. They also pointed out that, if we were to require some sort of indicia of ownership beyond legal title, it had the risk of collapsing the owner and operator categories in CERCLA, which could then render the operator category of liability potentially meaningless. And as we know from statutory interpretation, that we need to give every single word and provision meaning, so they rejected that approach. I also wanted to point out that the Friedland court had decided that while they had accepted the United States argument that they did not have sufficient control over the property and said that the United States couldn't exclude individuals from land subject to unpatented mining claims, and therefore that was indicative of the fact that they didn't have sufficient control over the property to be considered an owner. But the 10th Circuit pointed out that actually there are a number of cases decided by the United States Supreme Court that mentions that Congress has that broad plenary property clause power over national forest land, and just because the United States Forest Service may choose to not exercise those broad property clause powers doesn't mean they don't exist, and so it rejected that reasoning as well. So given that decision, that legal analysis, that just by virtue of having the bare legal title to the unpatented mining claim could make the Forest Service a PRP, or a potentially responsible party under CERCLA. That was the legal analysis. But then, as Ethan was talking about, there are other factors that play into whether how much a potentially responsible party is actually going to have to pay for cleanup. And allocation or contribution is perhaps what this first bullet should say. It's an equitable determination, as Susan mentioned. A court will decide, which PRPs, which entities are responsible for what part or percentage of the cleanup. And so the 10th Circuit was very clear about the fact that it was not deciding that issue. It was really just focusing on the legal issue of whether the United States Forest Service could even be considered an owner under CERCLA for purposes of that liability. And so it has a couple of points about how it wasn't deciding how much the Forest Service might be on the hook, so to speak, for paying the cleanup. But I wanted to point out the opinion has two mentions of this, and I think they're a little potentially contradictory. I haven't been able to entirely square them in my mind. I wanted to point them out. The first one is that second bullet, and the 10th Circuit Court says, of course, a bare legal title holder may in fact be liable for only a small or perhaps no share of remediation costs as a matter of equity. In other words, Forest Service, we might consider you an owner under CERCLA, but you may be able to walk away with zero responsibility for cleaning up or for those remediation costs. The second point is in a footnote. It's footnote 1 on in the opinion, and I think a little contradictory. It says, because we remand to the district court to address equitable allocation, we take no position on whether a party's status as a PRP precludes a determination that its equitable share of response costs is zero. So, you know, in the first point, it's saying perhaps no share of remediation costs. That might be a possibility. In the footnote, it says they're not taking any position on it. So when I read the second bullet, I think, well, it kind of sounds like they're taking a little bit of a position on the fact that maybe there's a possibility that there would be no share. Anyway, I want to point those out because I think they're interesting, and the court and the case is remanded to the New Mexico District Court, and so that equitable piece is still being figured out. The final thing I wanted to mention is that you know, there are different laws that allow federal agencies other than the EPA to take response actions at Superfund sites. And because we've been talking about the Forest Service, I'll just mention Executive Order 12580 because it discusses the Forest Service's authority to perform CERCLA actions, certain response actions in specified circumstances. It's not nearly as broad as what EPA has the authority to do, but it does allow them to take certain response actions. And, you know, this is one of the things that I think we're grappling with in light of the 10th Circuit decision, which is, you know, we have Executive Order 12580 out there that talks about the Forest Service taking certain response actions at Superfund sites and really acting as a partner with EPA. And then there's also the tension around, well, you know, could they also be considered an owner under CERCLA, and are they therefore a potentially responsible party? And how do those two pieces weave together and play out? So just wanted to leave you all with that exciting slide, that there are a lot of questions unanswered moving forward, and it's something that we're definitely going to be grappling with in Region 8 probably for years to come. I think that's my last slide. Yep.
Okay. Susan, I think he
Oh,
needs us to.
Do we need to?
Whoops. Do we have to unmute him?
I don't know.
Don't talk. We're unmuting you. He's trying. Can you just hit that little speaker thing on his, or?
Yes. So we're unmuting, but,
Doesn't want to unmute him.
Robbie, can you hear us?
Yes, I can hear you.
Okay, great.
Hi, we can hear you too.
Very good. Good morning or good afternoon, ladies and gentlemen. I'm taking this call from the San Francisco Bay Area. My name is Ravi Arulanandam. For many years, I was a regulator for California EPA. So I'm going to talk to you all about my own experience as a regulator and now as a in the private sector. This universe of hazardous waste and navigating through this universe of hazardous waste is very complex. When I was a regulator, I have facilities, and it took me a long time to learn the world, this complex world of hazardous waste. What is waste? What is a hazardous waste? And how do you determine you have hazardous waste? So it's going to be impossible for me to give this whole world of hazardous waste in 20 minutes. So I'm going to try to summarize this in just 20 minutes. As you know, in 1976, when RCRA was formulated, it gave a framework to properly manage hazardous and non-hazardous waste. And I'm only going to talk about a very small subsection of hazardous waste, because first it has to be a solid waste before it can be a waste. We produce so many waste through our industrial operations, but not everything is hazardous waste. First it has to be a solid waste. Solid waste means it does not need to be a physical form solid. It can be liquid, it can be sludge, but EPA has a definition, what is a solid waste. For example, household domestic sewage is not a solid waste. Scrap metal is not a solid waste. So first it has to be a solid waste, then only you can think about whether this is a hazardous waste or not. So not all hazardous waste also are considered for regulation. For example, household hazardous waste, used oil filters are not considered as a hazardous waste and are not regulated. So I'm going to talk to you, or going to describe to you how do you identify hazardous waste. All hazardous waste are based on 4 types of hazards, and you probably see this sign many times when you walk around in your town. There are empty properties where people are doing investigations, and there are some drums, and you will see these drums are labeled with hazardous waste. And what is this hazardous waste is what we are going to talk about. And next slide, please. So all hazardous waste have to have 4 characteristics: reactive, corrosive, ignitable, or is toxic. And there's a good website, EPA website, that describes all the 4 characteristics of hazardous waste. What is a reactive chemical, what is corrosivity and ignitability and toxicity. Let's look at some examples of each of that. Next slide, please. So what characteristics of reactivity? The definition in EPA's definition is it reacts violently with water. It forms an explosive mixture with water, or when mixed with water, forms a toxic gas. Very good example is you go into a plating shop and there are many waste and chemicals in plating tanks. Sometimes when you mix some of their chemicals can form toxic gases. Cyanide or sulfide bearing waste that can generate toxic gases when mixed with non-corrosive liquids. Similarly, in a plating shop, you come into that situations. Capable of detonating under a strong initiation source of heat in confinement. So these are some of the characteristics of waste and materials that are classified under reactivity. A good example that comes to my mind these days is you see these scooters all over town running, and these scooters have lithium batteries. And if you accidentally dump one of these scooters in a lake, when these lithium batteries come in contact with water, there can be some explosion. Because I have seen this in Oakland, there is a lake, and kids take these scooters and they dump it there, and there's a good chance of lithium batteries coming in contact with water and having explosions. Next slide, please. Characteristics of toxicity, corrosivities. The definition of corrosivity is any liquid that has a pH of less than 2 or a pH greater than 12.5. But the household vinegar, it has a pH of 3.3, and it is not corrosive. But if you take the vinegar at a very high concentration, like 60% vinegar, you can use it to etch your concrete floor. So concentration is very important. Vinegar foam is not corrosive, but 66% vinegar be corrosive and considered hazardous substance. Similarly, also the sodium hydroxide or the lye that we use is not corrosive, but in pool, when you use it for cleaning your pool, that substance at the time can be corrosive and can be considered hazardous waste. Next slide, please. Characteristics of ignitability. A solid capable of causing fire through friction, absorption, or moisture, or spontaneous chemical changes burns vigorously to create hazard. The ignitability has some flash points. If it is less than 140 degrees, it's considered an ignitable liquid. Gasoline is ignitable, but not diesel. So it depends on the flash point. Similarly, also for gases, methane gas, propane gas, many gases that come out of the landfills are considered ignitable. And oxidizers, as defined in 49 CFR, defines what is an oxidizer, and they are considered ignitable. Next slide, please. Characteristics, toxicity. So initially, this was based on the 70 Safe Drinking Water Standards. The federal EPA listed 8 metals, 4 pesticides, 2 herbicides, 26 organic compounds, D-waste, D004 and D043 waste codes were listed as toxic chemicals. Primarily, these are large organic molecules that are bioaccumulative, and then they are toxic to plants, animals, and humans. I will show you the 8 metals later. And next slide, please. So how do you determine toxicity? Toxicity determination. Liquids can be tested using any method as long as it is documented quality control. So when you are going to do this test and somebody's regulators are looking at your tests, you better make sure that you have good documentation how the liquid was tested for its toxicity. Solid also must also go through a procedure. For solids, what EPA came up with is called a toxic characteristic leaching procedure. What they're trying to do is, if this chemical is dumped in a landfill and it goes through over years and it leaches from the landfill, gets into a drinking water source, will it be toxic? So they are trying to mimic landfill conditions by putting these chemicals in a flask and shaking for many hours in an acid and to see what the leachate is. So toxicity is determined by what comes out of the leachate. Next slide, please. In 1990, EPA promulgated a toxicity test. Basically, what they do is they take a certain amount of the solid and put it into a tumbler, 20 parts to 1 part of acetic acid, and they shake it for 18 hours, and then they filter the extract and analyze whether you had any chemicals in that leachate. So that's a very simple procedure called TCLP, toxic characteristic leaching procedure, very commonly done, very simple procedure. Remember, it's 20 parts to 1 part, because in California, it's a different acid, 10 parts to 1 part sample, and it for a longer period. So the same test in California is very different, but EPA nationwide, you do TCLP to see whether your solid is toxic or not. Next slide, please. So here are the 8 metals that are toxic under the TCLP rule: arsenic, barium, cadmium, chromium, lead, mercury, selenium, and silver. So these test results are compared in milligrams per liter, because that comes in a liquid, and you compare against the table and see whether you have exceeded these numbers, then it is a toxic chemical. So equal or greater than the reporting limit makes the waste material a hazardous waste in the federal hazardous waste. Next slide, please. I want to talk a little about California. It's a little different to the federal criteria. California's version of toxic constituents, it has more metals. It has a table for bioaccumulative or persistent chemicals, and California both has a liquid threshold and a solid threshold. In the federal standard, you only look at the liquid that comes out of the TCLP, but in California, you also look at the solid, what is the total concentration of metals in the waste. Next slide, please. So California, generally the criteria for hazardous waste is evaluates agents shown to cause hazards to health or environment. Generally, chemicals waste that is can cause harmful effects to health and environment. It has 20 metals as opposed to 8 from the federal RCRA standards. Has 18 persistent or bioaccumulative toxic substances. And the way you determine them is you have to do a toxicity test, and if the oral lethal dose is less than 2,500 milligrams per kilogram, it has a dermal lethal dose, it has an inhalation lethal concentration. You also have to do a 96-hour aquatic bioassay to determine whether these persistent or bioaccumulative substances are considered hazardous or not. In addition, it also has a weight-listed constituents for 16 OSHA carcinogens. So determining hazardous waste in California is an art, and sometimes it takes a good amount of experience to learn, to get to know how do you navigate through all of these criteria before you can determine you have exceeded or you have a substance that is hazardous or not. Slide, please. So in California, TCLP, California replaces TCLP with TTLC and STLC, I said. TTLC is the total threshold limit concentration. STLC is a soluble threshold concentration. So TTLC is very simple. You digest with acid and find out what the total concentration is. There's no dilution, and you simply find what the total concentration is. STLC also tries to mimic the landfill condition, but it's done a little different to TCLP, and I'll show you the difference between TCLP and STLC. Next slide, please. So California's wet procedure is used for, as I said earlier, used for 17 metals, 2 inorganics, asbestos, 10 pesticides, and 8 other organics. Solids are milled to 0.45 microns, and it's mixed at 10:1 ratio, not 20:1 as TCLP, not acetic acid, but uses citric acid to dissolve it, and then it also shakes for 48 hours as opposed to 18 hours in the TCLP. And the leachate is analyzed, so it's a much more, I would say, it leaches out more chemicals by this procedure compared to TCLP. Next slide, please. So here are the additional metals in California that you need to consider: antimony, molybdenum, nickel, thallium, vanadium, zinc, beryllium, cobalt, and copper are additionally considered hazardous if found more than the threshold limits as hazardous waste in California. Next slide, please. Chromium, California differentiates chromium-6 and chromium-3. In RCRA, it's only chromium-3. California has an STLC limit for chromium-3 only if the waste passes a TCLP process. Chromium is a little different in California. Next slide, please. Asbestos is also considered hazardous waste, especially if it is in a friable, powdered, or finely divided states. Mostly old buildings that are going through abatement, you need to take extra care whether you have asbestos as hazardous waste or non-hazardous waste. You don't have a STLC for asbestos, you just count the number of fibers in the air and water to determine whether you have hazardous waste or non-hazardous waste. Next slide, please. So in determining hazardous waste in California, typically TTLC is run first to find out what the total number is. Then if the TTLC results are less than, if the results are less than the TTLC numbers, see if they are greater than 10 times the STLC numbers. So you need to have your TTLC table and your STLC table in front of you to compare the TTLC number for whatever chemical you are looking for. If it is less than the TTLC number, then it is not a hazardous waste, but you still have to look at whether it is 10 times greater than the STLC number, because you are 10 times in your STLC. If it is greater than 10 times, then you have to run your STLC. If it is below the STLC, only then it is non-hazardous. If it exceeds the STLC, it may be less than the TTLC, but if it exceeds the STLC, then it's hazardous waste. So you need to know how to do both the tests. But in a Dig and Haul, in my private practice, I do a lot of work where people are Dig and Haul. I don't waste my time doing TTLC. I just go and do STLC, because if STLC, if I pass the STLC, then it is not a hazardous waste. I don't need to waste my money on doing TTLC every time. I directly go and do STLC. But if it is a ordinary facility that they are regularly producing hazardous waste, they may do TTLC and then do STLC. And if the results are greater than TTLC, then at least it's a California hazardous waste. Then you also have to see if the results are 20 times greater than the TTLC, then run a TCLP to see whether it is a federal waste or not. It may not be a federal waste, and it may not be California hazardous waste by STLC and TTLC, but in California, you still have to do 6 more toxicity criteria to check whether it is hazardous waste or not. So it's very onerous in California to pass all the tests before you can say it's not a hazardous waste. Next slide, please. Here's an example for you. I have I have a beaker full of waste, and then let's assume that both have 100 milligrams per kilogram of lead. So the concentration of lead in my waste is 100 ppm or 100 milligrams per kilogram. And if you run the TCLP, and let's assume in my waste 50% leaches. So TCLP is 20-to-1 dilution. So 50 milligrams per liter divided by 20, the result is 2.5 milligrams per liter. The TCLP number for lead is 5 milligrams per liter, so it is not a RCRA hazardous waste. The same sample, if you run California's leaching procedure, it also leaches 50%, but the dilution is 10-to-1. So 50 milligrams per liter divided by 10 results in 5 milligrams per liter, and 5 milligrams per liter is the STLC for lead. So you fail the leaching test in California. So it's not a RCRA waste, but it's a California hazardous waste. So it takes some time, experience doing this, then you will figure it out. How to navigate this world of where you're going to send your hazardous waste, because you need to find a place, a landfill that will take it. So some of them can take RCRA waste, some of them cannot take RCRA waste, some of them can take California hazardous waste, some of them cannot take hazardous waste. So you need to figure out these tests to send, where to send your hazardous waste. Next slide, please. I want to talk a little about scrap metal, because California has many scrap metal recycling facilities, and scrap metal is not considered a solid waste because it is not a solid waste. It is not a hazardous waste, but it has some exemptions, and I want to go through those exemptions. Next slide, please. So scrap metal recycling exemptions. Both US EPA and Cal EPA excludes scrap metal from hazardous waste requirements. The definition for the exemption is not the same. The California's exclusions are more stringent than the federal exclusions. Let me go through what they are. Next slide, please. California excludes from scrap metal lead acid batteries. So you cannot send lead acid batteries to a scrap yard and say they are not hazardous waste. Magnesium borings, beryllium borings, any metal contaminated with hazardous waste, any metal free-flowing oil that is hazardous waste, and sludges and fine powder cannot be considered under the exclusion. They are considered hazardous, and you can't hide behind the scrap metal exclusion. And so most of the scrap metal yards in California are under a lot of scrutiny, what they can accept, what they cannot accept. And it's very hard to manage these scrap metal yards because truck after truck comes all the stuff, and these facilities have to carefully watch what is coming into their facility. Otherwise, very soon they will get into trouble because you don't know what comes. Sometimes they pick up this stuff from all over the place and they bring it to the facility, and you need to really pay attention to what comes into a facility in California. Next slide, please. I want to just quickly touch on acutely hazardous waste. In California, we call it extremely hazardous waste for a second. Next slide, please. RCRA also has acutely hazardous waste. They come under the P-list waste. Mostly P-list waste are unused chemicals that are in P-list. And any 1 kilogram threshold for any given month for large quantity status, if you are producing these P-listed waste greater than 1 kilogram in large quantity status, you come under the acutely hazardous waste. You have to produce biannual reports. The containers must be triple rinsed before you consider empty. Must be from an unused single ingredient material, and there are more requirements for acutely hazardous waste. Next slide, please. In California, the criteria is found in section California Code of Regulations 66261. And in California, the oral LD lethal dose 50 is very small. So any chemical that has a oral lethal dose of less than 50 milligrams per kilogram, as opposed to 2,500 previously I showed you, and dermal less than 43, and inhalation concentration less than 100 ppm gas is considered an extremely hazardous waste. And they have very strict reporting requirements if you are producing them in a facility. Next slide, please. So you have to, pollution prevention plan required, and other requirements. You have to follow many other California requirements if you are producing extremely hazardous waste. I'm not going to touch on mixed radiological waste and hazardous waste. Radiological waste are regulated both by EPA and by NRC. That's a very separate topic, and stop at this point. Thank you. I appreciate it.
Okay. All right, now what you've all been waiting for. So I'm going to talk a little bit about RCRA, which, as the DC Circuit said, is a mind-numbing statute. But don't worry, we're not really going to go all the way down there. My goal here is just to teach everybody enough to be dangerous, to know enough, and then to know when you don't know enough. The first thing I want to clarify, I actually teach environmental law at Georgetown in the evenings. And every year when I do the exams at the end, I get a whole bunch of answers back, which makes it clear that I have not actually adequately explained the difference between Superfund and RCRA. So I just want to touch on that because we're doing both today. And there are so many similar sounding topics that I thought we should just clarify that. Superfund is generally abandoned waste sites, sites where somebody put the hazardous substances and you aren't really sure. Maybe you know who owned it. Maybe a lot of people owned it, but it's generally what we think of as an abandoned waste site. RCRA is the statute that applies generally when you have an operating facility that generates waste. So when you're thinking about it, you know, if you've got a manufacturing facility, probably RCRA applies and Superfund does not apply. And I'll touch a little bit more on some of the terms that seem similar, but actually are quite different in those two contexts. RCRA was enacted in 1976, first of all, and the idea was to have sort of a cradle to grave regulatory scheme to prevent hazardous waste from making its way into landfills and making its way into the drinking water and the soil and the air and to its way to people. After 1976, as Susan said, then we had Love Canal and Times Beach and other things where Congress realized that they actually already had the problem that they were kind of trying to avoid with RCRA, so they enacted Superfund to clean up the sites where they aren't imposing this regulatory scheme on an acting facility. So the goal here is to avoid land disposal and minimize waste. And it is done largely through a scheme of manifesting, so you can track where things go. These are just the EPA biennial statistics on hazardous waste that I found interesting. If you go back and look over time, you'll see that these numbers actually don't change very much. So I think in the scheme of things, we're probably not so much reducing the amount of hazardous waste we're producing and disposing of. About 25,000 facilities generate hazardous waste. And most interesting to me, sort of 5 states generate 71% of all waste: Texas, Louisiana, Ohio, Indiana, and Mississippi, which tells you something about our manufacturing. Those numbers have not changed very much over time. Okay, so why does it matter? The goal of this is to figure out where you're going to put your waste and how it's going to be managed. And there are 2 subtitles that we talk about that I'll just touch on here, and a little bit further we'll get a little bit more in detail. Subtitle D is non-hazardous solid waste. So that's kind of your regular landfill, although you can't dump open waste, and there are minimum federal criteria for operating a landfill in the hope that your landfill will not turn into a Superfund site after everybody has dumped all of their stuff. I have many a case that involves a landfill. Right? Yeah. Subtitle C are the rules that apply when you have hazardous waste. And as Robbie talked a little bit about there, and I'll touch on in a much thinner way because I don't have the same technical background, you really have to understand you have non-hazardous solid waste or solid waste. Subtitle C has very onerous regulations if you have a hazardous waste. How does it work? And I'll talk about this. And this is how I think about it whenever I come to a RCRA problem. First, is it a waste? And we'll talk about that in a minute. Then, is it a solid waste? And if it's a solid waste, is it a hazardous waste? If it's a hazardous waste, there are rules for generators, transporters, and treatment, storage, and disposal facilities. And the focus is generally on waste minimization and the proper handling and disposal of waste. And increasingly, there has been a big emphasis on recycling and reclamation, too. That's part of the waste minimization. Okay, so this is how I think about it whenever I have a RCRA issue. The first is it a waste? Did somebody throw it away? Did somebody discard it? It's not always the easiest question to answer. I can give you the example of a facility that makes a particular process, and one of the byproducts of that process is the same material that you all use for pizza stones. And they might throw that material in a landfill because they don't really need it, or maybe they sell it to people to sell as pizza stones. And so, there's a question: is it a product or is it a waste? Is it really a waste that they're gonna throw away? So, and the question is, if it's a waste, you need to know who was the generator. And I always think about, so in Superfund, we talk about owner and operators and the people who arrange for disposal. In RCRA, and at the point they make the decision that it's a waste, it becomes a waste and they become the generator. But it's a little bit of a state of mind. Once it's a waste, you have to ask yourself, is it a solid waste? when I first moved to DC in like 1986, I interviewed for a job at the Office of Science and Technology, which was then part of Congress on the Hill, and they were asked me if I knew anything about solid waste, and of course I knew nothing about solid waste, but I thought, how hard can it be? It's a waste that's solid, and in fact, I did not get that job, not surprisingly. So, you know, if it's a waste, it's probably a solid waste. There are some exemptions we'll talk about, and then the next thing you think about is it a hazardous waste? And that's where you get into these questions of, is it characteristic or is it listed? If it's a hazardous waste, subtitle C applies. If it's a solid waste, subtitle D applies. Again, this is the statutory definition of solid waste, and I just want to bring your attention to the sort of discarded material. That's, you know, so when it is a discarded material, it becomes a waste. And the other is that it can be a solid, a liquid, or a gas. As I learned from my job interview, it does not actually have to just be a solid. It can be a liquid or a gas, although the gas has to be containerized. There are exclusions to solid waste. Again, as Ravi said, domestic sewage is an exclusion. That's not considered solid waste. If you have a waste and it's controlled by a NIPD's permit under the Clean Water Act, the RCRA does not apply. That's excluded. And then there are a bunch of others, but I won't go through them because that's more than you need to know. So the regulatory definition of solid waste, a solid waste is any discarded material that is not excluded. And so it raises a question of what is a discarded material. If you read further on down, it basically says a material that is abandoned. I know, not all that helpful, but you get sort of the general idea. And further on in the regs, they talk about what does it mean to be abandoned, disposed of, burned or incinerated, accumulated, stored, or treated, but not recycled, or sham recycled, which we're going to talk about. And that's a little bit exactly what you think it is when someone pretends they're recycling in order to not be a solid waste, but they're really just like pretending to recycle a waste that otherwise would be probably a hazardous waste. There's a ton of regulation and litigation on that particular topic. Certain recycled materials are excluded from the definition of solid waste. So if the waste is used as an ingredient, if it's a waste but you use it as an ingredient, it is now magically not a solid waste. If the waste is used as a product substitute, again, if you put it directly back into your process as a product to help make whatever it is you're making, it is now no longer magically a waste, even if in your head a little bit before it had been a waste. And similarly, waste returned to the production process. And that's just, you know, something to think about. Are there, if you have one of these problems, is to think about, are there some exclusions to the definition of solid waste? And you should go look. And you can generally avoid the RCRA regulation entirely if the waste is properly recycled. There is a ton of litigation about this issue. All right, so, and this is the focus on this, is it real or sham recycling? This particular question has been litigated. I mean, if you put it up, it's actually sort of absurd. There were certain regulations that were enacted in 2008, and then the DC, it went up to the DC circuit and people challenged it, and certain things got reversed, and then new things got put in place, and then those things got reversed. And most recently, the DC circuit reversed what was done, and I think sent us mostly all the way back to 2008 on this. But again, for these purposes, you don't need to know the history. They're just, I think if you actually had one of these problems, you need to go read the regs and history. But the main thing is to be aware of it and to keep a few things in mind. So what do you think about on whether or not it's really recycled? Is it a useful contribution to the recycling process, or are you just like sliding it in there to get rid of it? That's, you know, if you're actually recycling it within your own manufacturing process. Does the recycling process, if you sell it off, does it create a valuable product? Are you, is someone sham recycling it and then just, basically throwing it away? Or are they making fleece, recycling? I don't think plastic bottles they're maybe solid waste, but they're not hazardous waste. Are they making a nice Patagonia fleece out of it? That would be a useful product. Are they managing the hazardous secondary material like it's a valuable product, or are they just like putting it in the back in a bunch of tanks and they're not really managing it like it actually has any value? And is the product comparable to a legitimate product? Like, does it have a lot more lead? That's probably not so good. That issue is very complicated these days. The DC Circuit just spoke to that as well. These are elements, these are considerations, these are, you argue for and against as you think about whether or not it's recycling, and what you would say to EPA when they say to you, we don't think this is real recycling. You want to be able to think about why you think it is real recycling. There is also a generator-controlled exclusion and a transfer-based exclusion, which I think have now been left in place after the most recent DC Circuit decision, which was about 2 weeks ago on this. And that basically says, the transfer-based exclusion basically says, every time, it's not waste every time you send something from a generator to a reclaimer and they pay you some money for it. But what the EPA is really trying to get at here is the disposal of hazardous waste under the guise of recycling. And you do really need to pay attention to that. If it is a hazardous waste, you are in subtitle C. As I said, it's kind of a manifest system. The moment you become a generator, you have to do a waste manifest that says who you are and where you're sending it and what you're sending it. That then goes to the transporter, and then it gets recycled, disposed, or landfilled, depending on what it is. But the idea is that EPA can track it. You have to send your waste manifest to EPA. If things go south where you're sending it, and it becomes a Superfund site, EPA will pull all those waste manifests and they will come knocking on your door, because they'll be able to say that the company that you dealt with sent this amount of weight to this location. I won't go through this. It's just each one of these generators, transporters, TSDFs, treatment, disposal, storage facilities, they have their own regulations. You want to be aware of those. All right, what is hazardous waste? Ravi just gave, I think, a pretty in-depth discussion of that. And basically, these are substances that pose a substantial threat, hazard to human health or the environment. And how do you know? So 2 ways. One is it's a listed waste, and that means it's listed. And you can go to the 40 CFR, there are lists that will list all of those wastes. There are certain categories of waste, F, P, Q, U, and you can, if you're dealing with a particular waste in a facility, you can actually go and say, all right, it's this waste and it's a listed waste. What happens pretty often is whether or not it's a characteristic waste. Does it hit one of the 4 characteristics? You do the T-clip to figure some of that out. I'm a lawyer. I would hire somebody like Ravi to actually do those tests for me and tell me what he thinks. But I don't know how many of you are lawyers, but you need to sort of understand what is the process, what are they looking for, so that you can ask a lot of questions to make sure that the testing is done properly and that you understand what you're dealing with here. So if it's a hazardous waste, you're in subtitle C. Now, why does that matter? Subtitle C has some very onerous regulations that apply, and very comprehensive regulations for the management and the operation of treatment, storage, or disposal facilities. And so it is expensive and it's complicated if you are in subtitle C. Subtitle C, Subtitle D has a lot of regulations as well, but it's not quite as complicated as Subtitle C. And so you might have something, if it's a solid waste, you can send it to a Subtitle C landfill or D landfill, which is a little bit less protective, maybe is maybe the right word, than a Subtitle C, which has to be double lined and has a lot more regulation around it in order to prevent the contamination that's going in there from spreading. And also, if you're the manufacturer, if you're the generator, you are going to have a lot of RCRA regulations that apply to your particular processes. All right, so if you ever have a problem where somebody says, I think RCRA applies, does RCRA apply to this process? I have two, you go through the process of thinking, is it waste, is it waste, just solid waste, hazardous waste? And there are, I think, two really helpful resources for figuring out how EPA thinks about that. The first is you can go to a website that's, and you have to do an advanced search on Google, yosemite.epa.gov, and put in your search terms, and you search that domain. And EPA has had the RCRA hotline, and they have a lot of questions and answers, and they post them there, and you can read them and figure out if they are, the answers that EPA give are relevant to the problem you're trying to solve. Or you can, put a few of them together and extrapolate to the problem you're trying to solve. And the other is a book called RCRA Unraveled, which is actually a fantastic book on explaining RCRA, that if you ever have one of these problems, you should do. Just very quickly, other important RCRA provisions. Beyond the regulatory regime, there are enforcement provisions, and I think the RCRA sort of enforcement provisions are pretty important in environmental law. So the first is, if you have a release, EPA will require you to do a corrective action. That's a little bit like a Superfund cleanup, but it is under RCRA, and it is managed under RCRA. So there's separate requirements there. Enforcement, there are of course enforcement provisions. If you do not comply with RCRA, there is civil enforcement, there is injunctive relief that they can get, and there are the maximum civil penalties for violations are a little over $72,000 per violation per day. That's the maximum. That adds up, so you don't want to go there. And then criminal enforcement, which is often lying on forms, a problem maybe a facility can have, where someone lies on a form, that can cause criminal liability, and you need to worry about that. And then knowing endangerment, 15 years or $250,000 per violation. RCRA also has citizen suits, and a lot of citizens use the RCRA citizen suit provision. It is for permit violations, and it is also for imminent and substantial endangerment. And as Susan said, that is often not quite as imminent as you would think. And so citizens can use the RCRA citizen suit provision to sue, a manufacturer or somebody that is regulated by RCRA for, a substantial endangerment that might be 10 years down the road. That is a pretty well-used provision, section 7002. So just something to be aware of. It has the same sort of like 60-day notice under RCRA, and you have to let the state know. If the action is barred, if EPA is also already pursuing. And you can use it against EPA for failure to undertake mandatory duties, but it really has to be a mandatory duty. And the court can award, if you do it, the citizens can get costs and attorney's fees. And it's an important provision to know about because it is so widely used. And then imminent hazard, section 7003, This again is basically a codification of nuisance law. This is another one that if you are in private practice, people will use all the time in an effort to stop whatever it is you're doing that they object to. And again, it is solid waste or hazardous waste. It's very broad, and it is a pretty important tool, I think, for citizen groups to know about, and they pretty often use it. EPA as well uses it. Injunctive relief is available, and so it's another one where you don't really have to show you violated exactly this regulation. You just have to show an imminent and substantial endangerment, and then you can kind of go from there. So it's a pretty important tool to know about. And that's it. RCRA in a nutshell.
All right, thank you so much. I'd like to open the floor up for some questions for our panel.
Hi, first of all, thank you for being here and for a great panel. I was wondering if you guys could talk a little bit about hazardous sites as an environmental justice topic and the fact that they are so disproportionately cited in and near communities of color and low-income communities. And I was wondering if you could talk a little bit about that specifically. Do any of the laws regulating hazardous waste and sites offer opportunities to acknowledge or to address this issue?
So for those on the webinar, this is Susan Akers. I certainly don't hold myself out as an expert on environmental justice, but there's not provisions specifically in CERCLA for environmental justice, but it's certainly something we're aware of when we pursue cases. EPA has online tools to find, to be able to determine whether it is an area with environmental justice concerns. And I believe there are also grants for communities to use for, getting technical assistance and things like that.
Yeah, the only other thing I would say is I would, there, as Susan said, who knows probably more about this than I do, but it's also true, I think, that EPA coming out of Flint has really, as I feel like we've experienced, has much more of emphasis now on actually not environmental justice sort of per se, but on, what is actually happening and what's happening in the community. I think Flint is sort of the first one, but there have been a few others where there might be a facility and they're operating within, as they're allowed to operate under the regulation. But if there's some greater concern, because we learn new things about these chemicals all the time, you may find that EPA actually decides that they're going to use RCRA to bring some sort of enforcement action and get injunctive relief to get pollution control in a way that I think we didn't see sort of as much pre-Flint. I think there is a heightened awareness of that. I don't know.
Yeah, and I would also say just about Flint and other similar issues, the Safe Drinking Water Act has relatively weak enforcement provisions, which makes it difficult for EPA to actually take action when something like that is happening.
Yeah. This is Erin. What I would add is that well, a couple of things. The environmental justice policy was just sent around the other day at EPA, reiterating our commitment to make sure that communities are identified when we're taking enforcement actions and that they're being engaged with in an appropriate way, and we can offer our support with the authorities that we have to do that. And the other thing I'll say is that Superfund has, I think, one of the more robust community involvement capacities. We have EICs, community involvement coordinators, that are involved from the get-go at national priority listed sites, Superfund sites, the bigger, more remedial focused Superfund sites. And I think that's one of the ways that we can try to approach environmental justice issues a little more conscientiously in a Superfund context anyway.
Thank you. Do we have any other questions in the room before we jump online? Yep.
So this is a very basic question. You've talked about who's liable and what counts as waste and hazardous. But what's the process timeline between somebody finding some sort of contamination and then these decisions being made? I mean, when does it start to be cleaned up? Who has to start cleaning it up? Or maybe it's not so basic.
Priorities, right? Yeah.
So as an example, I will tell you, I had a case in New Jersey, and you know, the investigation period can take quite a while. It can take years, and then there is the decision-making process when a remedy is selected. In this particular case that I was involved in, the remedy was selected in 1989. I was still litigating this case in the 2000s. So it can be a very slow process.
So the cleanup doesn't happen until the investigation of the remedy has all been decided.
Yeah.
Right, so there has to be an investigation both of the contamination and then an investigation to determine who are the potentially responsible parties. You know, after that, then there is a remedy selection. And then, as I said, there's two choices. EPA can go fund lead, or you can either issue an order or try to compel some sort of cleanup. But with the Superfund dwindling, it waits for some outcome in litigation because EPA doesn't have the money to go fund lead.
So I will say I have also a case in New Jersey where the emergency removal was done in 1982. So the drums that were on the site got cleaned up. And the remedial action has been, you know, the whole RIFS process has been going on since then. And EPA issued the ROD in 2012, I think, and we are now just doing the remediation of OU1 and kind of arguing a bit with EPA about OU2, which is in the Hudson River. And that's a case where there really wasn't litigation with EPA. That's just like the process takes a long time. It has a lot of community, you know, notice and comment, and you have to do it all under the APA. So it's not that slow, but it is true that the sort of the immediate problem of the leaking tanks, you know, that actually I think got cleaned up very quickly.
We're actually starting to, you know, as the Superfund program it's changed over time because sort of there were the most obvious cases that were dealt with initially, and now EPA is getting around to dealing with the most complex, difficult issues. And so we're dealing with a lot of river contamination, sediment contamination, and there are hundreds of potentially responsible parties, and there's contamination over miles of river. And I am involved with the Portland Harbor Superfund site and with the Lower Duwamish River in Seattle. And in those, the allocation process amongst the private parties, which has nothing to do with remedy selection, it can take years itself. Yeah,
Super ugly.
and just that process of them talking amongst themselves can take years.
Just to offer, oh, sorry.
Go ahead.
I was just going to say, I agree completely with what's been said about how long these sites can take, and just to offer something on the other side of the spectrum is that, you know, if it's a fairly simple cleanup situation and the potentially responsible party is willing and able to come to the table, you know, I've also had removal situations where we're cleaning up lead in a campsite, and we're done in a season, and the order is filed, and the bills are paid. So that's just kind of, I'd say that's the rare, but I didn't want to leave that situation out, that can sometimes occur if all the things line up.
Thank you. Do we have any other, oh, I believe Ravi has a comment as well. Hi, Ravi, can you hear me?
Yes, I can. I don't have any answers, although I know it takes a long time to work with regulators to get RAP approved.
Thank you. Do we have any other questions in the room before we jump online? Nope. All right. We did have one question regarding CERCLA. First off, they greatly appreciated that you clarified the distinction between generator and arranger. And
Probably someone in my class who I confused previously.
And their question was if you could explain what the typical arranger entity would be or what Congress had intended with this term.
So I mean, it's a super fun question, but I can answer. The person who arranges for disposal is a super fun term, and it's the person who is, so it's the manufacturing company that needs to do something with its waste and says, I'm going to send it to this landfill, and they have now arranged for disposal, but it can be much more complicated than that.
Right, it can, the classic easy case is exactly that. A manufacturer, as part of their process, has a waste product that contains hazardous substances and they have to dispose of that some way. They don't have to know where it goes or what happened to it, but they will be liable if it ends up creating a Superfund site. But then it, as I talked about a little bit, it can get much more complicated when you start talking about sort of a mixed situation where it may have some useful, some use for some other party, but but the intent of the party arranging for disposal is to get rid of it.
They had like the Fox River in Wisconsin where they took scrap paper that was cash registered, this, you know, so you could make a copy without using the old carbon copy, and it was coated in PCBs, and they took the scrap and sold it upstream to the paper factories so that they could recycle the waste paper and make new paper. But, you know, the question was, were they arranging for disposal of the PCBs that were on the waste paper, the company that downstream sold it upstream? So it can be more complicated.
Thank you. And we have a question for Dr. Ravi. You mentioned California's different toxicity criteria. Is it common for states to have differing criteria from the federal regulations, or is, you know, California unique in this environmental step?
I don't know any other states have that special requirement, but as a former California regulator, I know we have to go through so many other criteria before we can determine whether it's hazardous waste or not. I'm not sure, maybe New Jersey may have something more stringent than federal requirements. The states that are more stringent than federal requirements are New Jersey, Wisconsin, New York, maybe a few states, Washington, Oregon may have some requirements more stringent than the federal requirements. I don't know anything very specific states.
Thank you. Do we have any questions in the room, or I can continue on? Okay, perfect.
Hi, my name's Hillary. The National Priorities List, NPL, if I got that acronym right, do you need to be on that to initiate a CERCLA cleanup? And maybe the opposite question, can you have a cleanup without being on that list? How does that tie in?
So the National Priorities List is what will qualify the site for EPA to do a fund lead cleanup if they need to. You can still have in non-NPL sites, you can issue orders and you can have cleanup agreements for people to do the cleanup, and you can have removal actions.
And states have cleanup, so you might not have an EPA-led cleanup, but you might have a state-led cleanup. So, and states on the NPL. So there's usually one mechanism or another that's going to clean it up.
do we have any other questions for Jason? Okay, I'll take some online. We have another question regarding CERCLA generators and arrangers. In this case, it was under liability. And the question was posed as kind of a situation.
Someone has a summer associate project.
So, for example, if you hire a contractor to do work on your site and they generate waste that will be shipped off under the EPA ID number, could the site owner still have CERCLA liability if that waste ends up at a Superfund site?
Yeah, so there's actually a contractor-based exception under Superfund. So I might get that wrong, but there's if you hire a contractor to do the cleanup for you, they probably are going to be okay, and they would go after the owner. You don't, I think, get to hire a contractor and use them as a shield, or no one would hire a contractor. No contractor would be hired.
Right.
Yes. Yeah.
Any questions in the room? If not, we might just wrap up a little bit early here. For those folks online, if you do have any additional questions, feel free to send them my way and I can pass your message along. But I want to thank our audience for joining us today and for your great questions. We hope you'll continue to think and learn about hazardous waste and sites. You can stay up to date on our summer school series on our website, eoli.org. And on next Tuesday, July 23rd, we'll be diving into law and policy of product regulations, and feel free to join us here at 12:15 again. An enormous thank you to our fantastic panel, Erin, Susan, Rami, and Allison. Your vast knowledge on these topics have been absolutely fascinating and informative, and we're so glad that you could join us here today. And thank you all.